This is the speech for surface owners, those of you that own the surface but not the minerals, or those of you that own the surface and minerals that have signed a lease that doesn't give you the protections that you need. I'm going to give the speech as if you're the surface owner and not the mineral owner. It all applies the same, but I'm going to assume that so I don't have to say the same thing over and over and over and over and over again. The problem is that the surface and the minerals can be owned separately. That somewhere along the line, somebody owned the fee, owned the surface and the minerals, and they either deeded out the surface and kept the minerals, or they deeded out the minerals and kept the surface. That deed is called the severance deed. It could go either way. And we don't like it, but it's hard to argue against the fact that if Gary owns my minerals underneath my surface, if he can't use my surface to get to the minerals, we don't got nothing. So the law says, unfortunately, but not something we're going to be able to change, that he's allowed to do whatever is reasonably necessary to get his minerals out. He's going to need a well site, he's going to need an access road, he's going to need a pipeline, he's going to need a little bit of water, all that kind of stuff. He's going to need to do away with the water somehow. All right, so how is it decided where and how the well and the road and the pipeline are built? There are three sets of laws that apply. There's the common law and what your deed says. There's the DEP, state DEP, Soil Erosion and Sediment Control Manual that's applied during permitting and after the well is drilled. That's the second set of laws. And the third set of laws is the Oil and Gas Production Damage Compensation Act. It's the third set of laws. Talk about those three sets of laws to you. First, the common law and what it says in your deed. You got to go back and find the severance deed. Well, the deed from the person that sold it to me says I have the minerals or I don't have the minerals. That's not the severance deed. You need to go back and find the deed that originally split them. Go back till you find somebody that owned it all, and then come forward. That can be difficult. You may need a title lawyer. You may need an abstractor that will help you a little bit at the county courthouse, but you can't expect the clerks down there to do a complete title history for you. It's just too technical, and can be too technical and difficult. You start with that deed and see what it says. And generally it's not going to say anything good. It might say you get free gas if you're the surface owner. But it probably says they've got a right to do various, whatever is necessary to get necessary and convenient. Sometimes it even says without paying damages, et cetera, et cetera. So you got to go back and look at the deed. Maybe you get a break there. Most often it'll be free gas, but probably not. But what if it doesn't say much? And generally they don't say much. It just says, okay, I'm holding on the minerals, you own the surface. That's about all it says. So how is it, and who has decided who can do what? The common law says that the mineral owner is allowed to do whatever is fairly necessary that was within the contemplation of the parties at the time of the severance. The mineral owner is allowed to do to the surface whatever is fairly necessary that was within the contemplation of the parties at the time of the severance. I'm going to take a side trip here on the contemplation of the parties argument. It's not very useful very often. But where it arose from is the strip mine. Years ago, they separated the minerals from the people with particularly in southern West Virginia, somebody come along and buy the coal. And that was when people only knew that shaft mining was done, or coming in from the side. Then along, they developed strip mining. So the coal companies go, yeehaw, we own the coal. So they would start strip mining. And cases were brought, and even as conservative as the courts were, they said, no. Strip mining was not in the contemplation of the party. It totally destroys the surface. You can't do strip mining if the severance was way back then. Now, bring that to an 1890 severance of minerals here, when they drilled the wells by having oxen bring in something called a cable tool, which is about a chisel about this big around on the end of a spring something or other they call it. They would literally pound a hole down into the ground, and they'd drop a bucket with a flap on the bottom. And it'll take 60 or 90 days. It'll just, a guy there by himself working this thing. To some of the pictures that you saw. Was that in the contemplation of the parties at the time of the severance? I think it's a good case that you could win if the right facts, the right circumstances. But the case hasn't been won yet, hasn't been brought yet, and it may be difficulty because they're not entirely destroying the surface. The better argument, the more you can make that argument on your piece of land. If you get 10 acres and they're taking 5 for the well site, maybe you got an argument. So you can say that, but the test that's most likely to apply to you, and let me take another kind of side step. There's the contemplation of the parties. There's also, as I told you before, the horizontal wells. If it was a 100-acre tract, at the time the surface and minerals were separated, and the surface gets separated into a 25-acre tract and a 50-acre tract, and two 25-acre tracts and a 50-acre tract. The mineral owner can use any of those 25 or 50-acre tracts to get to his minerals, because that's the size it was when he bought it. So if you're one of those surface owners, they can use your surface to get anywhere on that 100 acres. But they can't go down and go off on another 100 acres, or another 100 acres, or another 100 acres. If they come to you, they want to negotiate a surface use agreement for a horizontal well, you can say no. Or you can get a whole lot more money out of it than you would otherwise. Your choice. All right. Well, let's assume we don't have a contemplation of the parties argument. Let's assume that's not a horizontal well. And that's just so important these days. Let's go back to what can they do to your land? The law says they're allowed to do whatever is fairly necessary. Some court cases, and this is all court law, this is not statutes. Some cases have said they have to give due regard to the surface owner's use. Some have said no undue burden. Some have said accommodation to the surface owner. All those words. And basically it's supposed to be a balancing test. They need to get their minerals out. You should have some rights, because you're a surface owner, to use your surface. My favorite example, they want to put a road down the middle of your meadow out on a place where you were going to build your retirement home, or your kids were going to build a home. It's a beautiful, level home site with a nice view. And you say, well, wait a minute, that's not necessary. You could put the road down the side of the meadow where it's not nearly as productive, and move it 200 feet, as I told you they can, and not be on my home site, and there'll be a well, and I won't like that, but at least I've got my home site left, and you guys can bulldoze that hilly area flat. And they want the shortest, easiest route, and you have your one, so it should be a balance. But what if they say, we're going to put the road down the middle, and we're going to build it on the home site? And you say, well, that's more than is fairly necessary. Unfortunately, the state can't help you here. The state is only concerned about soil erosion and sediment control and how the well is drilled, not where the well is drilled. They're concerned about how the well site is made and how the road is made, not where the well is made, generally. Not where the well is drilled, not where the road is built. So if they're going to do that, then your only option is to go to court, unfortunately. Now, some drillers, first of all, how do you know they're going to do that? Some drillers, probably most, will come out to you first and say, yeah, we're going to come out on your land, we want to do da-da-da-da-da. And then, if you got that kind of company, you probably have somebody you're going to work with. Lots of people call me, I don't know what the percentages of the total are, lots of people call me and say, I found a survey stake out in the middle of my meadow. That may be the first notice that you're going to have a well drilled on you. The only notice you're required to get under current law is 15 days. When they apply for their permit to drill the well, after they've already surveyed, if you didn't catch the survey stake, they've drafted the plan, they've got all this stuff, they file a permit with the state, and they give it to you, and they mail it to you. You have 15 days to comment on it. That's the only official notice that you get. So my number one tip to you as a surface owner is be prepared. You want the long version of this speech and lots of other stuff. I used to get these calls all the time because I helped draft that first building. So instead of giving a 20-minute speech to everybody I talked to on the phone, I drafted up a pamphlet, which became a book, which became a published booklet, I guess you would call this. We sell this, Julie, for how much?
15.
15. Join us for a little bit more and you get the book for free. But call, do we have some back here? We have a few to sell. If you don't get one, then if you don't get on the website, if you don't, call us, and we'll get you this book. Read this book because you've got to be ready, because the most warning you can have is possibly 15 days. Now, we have tried to get the legislature to pass a bill that makes it come to you before they do the survey, before they put the permit application together. Because once they put the permit application together, they paid a surveyor to survey the road, do the reclamation plan. They don't want to change it.